everyone. Happy end of June and happy Tuesday. Welcome all of you joining today's class. So happy to see you today. And today's class is very important to us. Are we seeing the end of the Tenant Relief Act? For this important topic brought to you by Western Gabriel Valley Realtors Education Committee. I'm Pauline Lam from Cotai Realty, your 2021 co-chair Education Committee, Western Gabriel Valley Realtors. A friendly reminder, all participants will be muted, and should you have any questions, please enter it into the chat box. Speaker will answer your question during the Q&A section. This section is being recorded and will be available on the YouTube channel, Western Gabriel Valley Realtors. Now, I'm so happy to invite Jeff Huang, our Education Committee member, to introduce our very special and important speaker, Attorney Dennis Block. Jeff, floor is yours.
Thank you, Pauline. Good morning, everyone. My name is Jeff Huang from eXp Realty. The Education Committee of the West San Gabriel Valley Realtors is happy to host today's challenging question. Are we seeing the end of the Tenant Relief Act? We're also going to talk about what are the ramifications regarding the Tenant Relief Act, what can landlords finally bring forth eviction cases, when can rents be collected, what is the rental assistance program, update regarding the rent control AB 1482. And we have a great guest speaker to guide us. I want to recognize this returning guest speaker as he is so gracious with his time. He already helped us earlier this year regarding this topic. Now, I have the great honor to introduce our guest speaker, Dennis Block. Dennis is the founder of the law firm of Dennis P. Block and Associates. His law firm spans 4 decades of representing income property owners. With a team of 19 attorneys, his firm has conducted over 200,000 evictions. His firms represented municipalities, the federal government, real estate management companies, and of course, mom and pop owners. He is the past president of the Apartment Association and has been on radio, talk shows, and newspapers. Mr. Block has conducted numerous seminars for fellow attorneys and income property owners. Without further ado, let's give a very warm welcome to our speaker, Dennis Block. Dennis, the floor is yours.
Thank you very much, Jeff. Appreciate the opportunity to speak to this wonderful group. It's always a pleasure. I had my topic and seminar all down. I had it prettied up, had bow ties around it. And then that pesky governor of ours changed everything on Friday. So I had to take the whole speech, throw it out the window, and redo it. And in fact, we're just kind of going over it now. And I can tell you that the way they changed the law is tremendously in favor of landlords, where tenants are going to just have to leave the house immediately and are going to be forced to give you all of their possessions. Oh, wait a second. I think I'm dreaming. That's not what it does. In fact, it does just the opposite. It shackles landlords to a degree that you're not going to believe. But before I get into the quote Tenant Relief Act, AB 3088, and how it got extended by SB 91 to the end of June, and now got extended to the end of September. It's incredible. But what I want to first talk about is statewide rent control, AB 1482. What properties does it cover? Can we serve some rent increases now, notwithstanding whatever else is going on in our wonderful world? So let's talk about statewide rent control. It's here to stay. I have so many clients who tell me, my property's not under rent control. It's not. And I'm going, well, I'm sorry, your property is, but I'm in Burbank. You know, I'm in a jurisdiction that doesn't have any rent control. Well, every jurisdiction in the state of California now has rent control because it's statewide rent control under Assembly Bill 1482. So are there some exemptions? Yes. A single family home is exempt. A townhouse or a condominium is exempt. A duplex is exempt from statewide rent control if the owner lived in one side of the duplex and lived there prior to the tenancy being created. So once again, you're not under statewide rent control if it's a single family home, a townhouse, a condominium, or a duplex where the owner lived there. And also if the property was built within the last 15 years, you are not subject to statewide rent control, okay? Which means that if your property is 14 years old, it's not under rent control, but within 2 years, it's gonna be under rent control. So keep that in mind when you're buying income property, that a building that has no rent control based on the way the statute is written, that you do need to have a wherewithal that you will be subject to rent control. So if you're subject to statewide rent control right now, today, you can raise rent. Nothing prevents you from doing that. If we serve a notice now under statewide rent control, you're entitled to, for the rent increase, 5% plus the CPI. So whatever those two figures are, add them together, and that's what the allowable rent increase is. Right now, today, the CPI is 3.6%. So if we add 3.6% to 5, that means for anybody with properties in LA County, Orange County, San Bernardino, or Riverside, you're entitled to an 8.6 rent increase. You can't make it effective prior to August 1st, so it's perfect. Serve it right now, today, or tomorrow, or the next day, and any property subject to statewide rent control, you would serve a 30-day notice, but make it effective as of August 1st. That's the first legal day. Otherwise, you're stuck with last year's CPI figure, which was only 0.7%, which means it would be a 5.7% rent increase. You don't want that. So we're going to make it effective as of August 1st, and we get the CPI 3.6 plus the extra 5%, so we're an 8.6% rent increase. So that's permissible right this moment. So definitely if you have property that is below market value and your property is subject to statewide rent control, you can raise rent. And it has nothing to do with the pandemic. Nothing is preventing you, if your property is subject to that statute, from raising the rents right now. If your property is not subject to any rent control, remember it was one of those exempt properties, like something built within the last 15 years, or a duplex where you're live in the unit and lived there prior to the previous owner, prior to the tenant starting, or a single family home, townhouse, or condominium, then you're not subject to any rent control. Right now, you can raise the rent to whatever you like. Today, go raise it. You can raise it to $1 million a month if that's what you want to do. There is no limitation. However, I should advise you that based on a relatively new law, if you're going to raise rent in excess of 10%, then you need to serve a 90-day notice. If it's 10% or less, it's a 30-day notice. So be in mind, there is no such thing as a 60-day notice to pay rent or 60-day notice to increase rent. You're going to either serve a 30 if it's 10% or less, or a 90 if you're going to go above. So that's, keep that in mind with regard to statewide rent control, and also with regard to the parameters dealing with properties that is not under rent control, okay? If you are under statewide rent control, and you are going to need to have good cause to evict a tenant. Right now, you can do that. For example, if you want to move in to the unit, then you are allowed to, right now today, serve a notice to quit. It would be probably a 60-day notice because your tenants probably lived there longer than 1 year. Otherwise, it's a 30-day notice. And then you would have to pay relocation money. The relocation money is equal to 1 month's rent. So if in fact, what you can do is an offset of the last month's rent. So if you're going to serve a 60-day notice, hey, I'm moving in. And of course, these notices have to be in accordance with the law. So you should have a firm such as mine prepare them. But in the notice, it's going to state that, hey, I'm moving in, or a close family member like a child, grandchild, parents, or your spouse are going to be moving in. Then you do have to tell the tenant that in the last month of his tenancy, that you will be getting free rent. That's your relocation. So that's a pretty easy one. If you want to remove a tenant, you can just have a close family member move in. One thing that you can't do is you can't say, hey, I'm planning on selling the property. For all you brokers out there where you have tenant occupied single family homes, not subject to any rent control, you could normally just serve a 60-day notice, but during this pandemic time, which I'll get into, that would not be a proper reason for either property subject to statewide rent control, or at this time, until the pandemic is declared over, and we'll get into that, you can't just ask a tenant to move because, hey, I'm selling the property and obviously I need for you to go. That is not a proper reason to evict a tenant. There's another reason that we can use in terms of eviction, but again, we can't use that until after the pandemic is over, which right now it's going to be October 1st. And that is, and it's actually a simple way to get around statewide rent control. So for everybody who has really low rents and that 8.6% rent increase is not making you happy, there is a way around that. And that is that you want to renovate the unit. We can't use the renovation excuse now, but we can as of now, since they just extended it to October 1st. So on October 1st, any property where the rent is really low and, an 8.6% is a nice increase, but really the market is literally half what it should be. So on that basis, what you would do is call our firm, and we would go forward on a renovation eviction, serving the tenant with a 60-day notice, giving the tenant his last months for free, and then you would have to do the work. Well, what work is required for a renovation eviction? It has to be substantial. Well, what is the definition of substantial renovation? Because again, this is your escape valve to get out of statewide rent control. So if anybody's suffering under statewide rent control, we got an easy way to get around it. We're just going to renovate the unit. So what's the definition of substantial renovation? Well, it's renovation that takes at least 30 days to complete. But, anytime you're going to do something in the unit, it's going to take longer than 30 days. And it also has to require a building permit, such as a plumbing or an electrical permit. So the bottom line is, if you want to have this tenant move because the rent's really low, redo the kitchen, redo the bathroom. You're going to need an electrical or plumbing permit. It's obviously going to take longer than 30 days. That's going to force the tenant to move with his last months for free, because that's the relocation that's given. And then you'll do the work. You got to do the work. There's no question, because otherwise people will come back and attempt to sue you. But do the work, and then you could rent out the unit for market value. So that's a simple way to get around statewide rent control currently as the statute is written. You can take advantage of this come October 1, when the pandemic statute is declared over by the state of California. And if you think about it, if your rent is really, really low for a unit, and I know that what you would be doing anyway would be to renovate the unit. So you'd be doing that anyway. in order to get top dollar for the property. Just like I did an apartment that I own in Studio City. Spent about $15,000 and renovated the kitchen and the bathroom, and obviously got maximum rent for my property. So tell all of your clients out there or family members or yourself that if you are suffering under statewide rent control, there's a simple way around it. All we have to do is hold our breath until October 1st. So those are the main keys with regard to statewide rent control. We've talked about the property that's not under rent control, that we can raise rent to market value. And also we can terminate those tenancies by a 60-day notice. The only proviso for property that's not under statewide rent control is that we can't get a judgment prior to October 1st. So if we serve the notice now, that's not going to happen, that we would get a judgment. So basically, we can terminate any property that's not subject to any rent control by just serving a 60-day notice. If the tenant's been there longer than 1 year, we know we can raise rent a maximum for non-rent control property to whatever we like. But if we're going above 10%, we need to serve a 60-day notice. If our property is subject to statewide rent control, then we know we're limited on our rent increases, which we can do right now. 8.6% effective August 1st. I encourage you to do that. We also know that right now we can ask tenants to move if ourselves, close family members like our grandchildren, children, parents, or grandparents want to move in. Again, we have to pay relocation. And then the last one, if we can get rid of any statewide rent control tenant, but that would have to be as effective as of October 1, that would be the renovation eviction. So that's your, in a nutshell, all about statewide rent control. So let's move on to the Tenant Relief Act. The Tenant Relief Act, that's what they called it. It's AB 3088 as amended by SB 91 and then amended over the weekend on June 25th, which extended it again. Now, they call it the Tenant Relief Act, but the truth of the matter is it really should be called a governmental assault on income property owners, because that's what this is. Currently, landlords have to go without rent based on these statutes for 17 months. 17 months is the way the statute was written, that landlords literally could collect zero rent and have no way of enforcing it. But that pesky little fun governor of ours, and by the way, please, everybody, please vote to recall him. On June 25th, he decided to extend it to the end of September. That's another 3 months. So if we think about it, it's not 17 months anymore. We're up to 20 months before landlords can receive 1 penny. You guys are all realtors. You know, you sell a property, escrow closes, and in a very short period of time, you're given your commission on the sale, right? You guys are happy, right? Can you imagine if the government said that, well, you can't get your commission for 20 months? 20 months. Insanity is prevailing with regard to income property owners and the onerous that our state of California, through our elected officials, have put onto the backs of landlords. And as I said in the last time I spoke to this group, no one is going to say that everybody suffered not only physical harm, but financial harm as a result of the pandemic. But no segment of society was enforced to support another segment of society. You don't have brokers that are forced to support other people. You don't have doctors that are supposed to support other people. Only income property owners are going to have to support tenants out of their own pockets. And how long? 20 months. 20 months. This is insanity, ladies and gentlemen. And during this 20-month period, do landlords have to pay their property taxes? Do they have to pay their mortgage payments? Do they have to pay utilities for the building like water and sewage? And in fact, if one of those tenants who haven't paid rent now for 17 months currently, and he says that his air conditioner is not working, does the landlord have to go and take care of that? And the answer is, of course. And if he doesn't, he could get a notice to comply by building and safety and literally have it turned over to the local city attorneys for that jurisdiction and filing a criminal complaint against the landlord. So what the onerous and obligations are placed onto the shoulders of landlords is true hypocrisy, true insanity, certainly against the fabric of what our country was based upon, which was, ladies and gentlemen, in case you didn't know, our country was based upon property rights. That's why the Pilgrims came here. They wanted to own land. And what we're seeing by our politicians is an erosion of property rights. And if they're coming after one segment, trust me, they're going to come after another segment of society. So we have to really stand up together as an industry and shout out what's happening to us and really try to resist at any level. So any advantage that you can take care of, please, you really should be doing so, like raising rents to market value as soon as you can, because the government's just coming after us. So what's this Tenant Relief Act all about? And now that it's extended, what new provisions have they put in? So let's go over that real quickly. I have talked about this before. There is 2 time periods involved in terms of rent being owed to landlords. One is called the protected time period. The other is called the transition time period. So the transition, actually, let's go first. For the protected time period comes from March 1st, 2020 through August 31st, 2020. So for that time period, from March 2020 through August 2020, that's called the protected time period. If a tenant owes you rent for that time period, technically you're supposed to serve a 15-day notice to pay rent or quit. The tenant, with that notice, you have to serve an information sheet, which explains the protected time period. You have to also send a copy of the law. And you also have to include a declaration that the tenant can merely fill out by signing his name and dating it. During that 15 days period, the tenant will have to do 1 or 2 things. He'll either have to pay you the rent in full. Well, that's not going to happen. Or he's got to return to you the declaration within the 15 days. If he does return the declaration within the 15 days, and by the way, the declaration basically states that the tenant has a financial hardship, and because of that financial hardship, could not pay the rent between March and August of the year 2020. Can you ask for documentation to prove it? Can I see something? Maybe something that shows you that you weren't working, anything? And the answer is no, you can't. All you can do is if you get the declaration, then the tenant has now complied with that 15-day notice to pay rent or quit. So when do you get the money, you might ask? Because you see, the politicians could never write a statute that says, okay, the money's just forgotten. They can't, because that would be against the Constitution. And that would be considered a taking, and you can't do that. So they, in effect, they put in some silly language, which in effect is a taking, but they use the language that the rent is deferred. Deferred. The truth is the rent's forgiven. Because you see, what they're doing is if the tenant returns that declaration, it is now not considered rent. They changed the name. They changed the name to past due rent to a civil debt. A civil debt. Now, why did the politicians change the name from rent owed for that period, the protected time period, to a civil debt? This is assuming your tenant has given you back that declaration. They did it because you can now never evict that tenant in an eviction case for that amount of money owed. Because you see, in an eviction case, you can evict for non-payment of rent. But those cute politicians changed the name. So it's not rent anymore, it's a civil debt. And you can't bring forth an eviction action against a civil debt. That's why they changed the name. So the politicians really want to tell you that you're basically being asked to waive all this money, but they call it a civil debt. So when can you now get that money? Okay, civil debt, rent. I want my money. When can I get my money? Well, right now, ladies and gentlemen, that money is due. This is for the protected time period from March to August of 2020. That rent is now, no, I don't want to call it rent. That civil debt is now due. Are you ready? October 1st, 2021. That's when the tenant has an obligation to pay you the civil debt. And if he doesn't, then you have the right to bring forth a civil lawsuit as of November 1st, 2021. So if you're scratching your head here, remember any rent owed from March 2020 through August 2020, if the tenant returns the declaration, which of course they'll do, whether it be honest or not, then they have to pay you that civil debt because it's not rent anymore and you can't evict for it come October 1. If they don't, then you can finally bring forth an action come November 1. Now, you can either bring a regular civil lawsuit, which my firm can help you with, or you can bring a small claims court lawsuit, and the small claims court jurisdictional level is now unlimited for the civil debt rent. So you'd have to wait till November 1. This has now been extended. It was July 1. We were doing this just in a few days, but now what occurred on June 25th, Friday, last Friday, he's now extended it to October 1 to pay it. And now you can't bring this civil lawsuit until November 1. Our firm will be assisting landlords in filing small claims court actions. That will be come in October. So check with our firm in October and we'll assist in helping you file small claims court, locating your tenant, serving your tenant, and preparing the paperwork that's involved, and also giving you some tips as to what to say when you go to court. But you see, if you wait till November 1 to file your small claims court action to get the rent for this quote protected time period, after you file that small claims court action, you have to serve your tenant. Well, what if your tenant moved? Where are you going to find him? So in effect, if you can't serve him because he's moved or moved to another state or he moved to Orange County or he moved to someplace, then you're not going to be able to serve him. So in fact, what do you got? You've got lost rent. So when the politicians told you it was deferred rent, you know what they were doing? They were lying, because that's what it is. 85% of this money will never be recouped by the landlord, 85% of the money. And I'll go so far as to say 85% of the tenants are gaming the system and really don't need protection under this so-called Tenant Relief Act, 85%. Do you know that at least 5 times a week, I have clients call me where their tenants have not paid the rent, and they tell me that their tenants just bought a new car. Their tenants just bought a new car. This is the system that we're in. It's kind of like the politician telling banks that, oh, you know what, banks, you're going to have to keep your doors open. And by the way, no security. If you do that, people are going to walk in and take samples. That's exactly what they've done with this so-called Tenant Relief Act, also known as the governmental assault on income property owners. Let's move on now to the transition time period. And by the way, when I tell you the true things of what occurred on June 25th, your head's going to fall off, but let's first get you to that point. So the transition time period is from September 2020 through now, oh my God, September 30th, 2021. Well, if you're good at counting, that's 13 months from September 2020 through the end of September 2021. That's 13 months. That's called the transition time period. If a tenant owes rent during that transition time period, you have to serve a second and a separate 15-day notice that just covers that time period. You also have to serve it with an information sheet, which explains about the transition time period. You also have to give them a copy of the law, the Tenant Relief Act. And lastly, you have to serve a second declaration. Now, after the tenant is served with that 15-day notice, they have 15 days to pay you in full. Well, that ain't going to happen. Or they have to sign the declaration and return it within the 15 days that they have a hardship for that transition time period and can't pay the rent. Again, can you ask for proof? No. If they say it and then you know your guy has, $300,000 in a bank account, it doesn't make any difference. You can't ask for any collateral proof. So if the tenant, the difference in the transition time period is if the tenant returns that declaration, they do have to pay 25% of the rent. They do. Now, logic would tell you that if you serve a 15-day notice and they return the declaration, that at least the 25% of the 13-month period or whatever is owed would have to be paid within the 15 days. That would make logical sense, but you see, this law doesn't make any logical sense. So the 25% is not due within the 15 days. So when is the 25% due, which is considered rent, by the way? And that is due as of September 30th, 2021. So for that 13-month period, they're going to have to come up with 25% of the rents. And if they do not, we're going to talk about that, then you're able to file an eviction. I am happy to tell you that there will be no more extensions to this rule. I know it got extended once from February 2021, then it got extended to June 30th, 2021. Now it's extended through September 30th, 2021. I mean, you need a scorecard, ladies and gentlemen. Thank God I have my notes right underneath my desk here. But there will be no more extensions. So that means on October 1st, if you don't get your October's rent, you're going to be able to serve on that wonderful tenant on October 2nd, a 3-day notice, a simple, lousy 3-day notice to pay rent or quit and bring forth an eviction. But what about the 25%? Well, first, let me tell you, as to the 75% of the rent, remember, because we're only talking 25, that also now becomes a civil debt. The tenant has to pay you that civil debt. It's not rent anymore, and we know why it's not rent, because you can't evict for it. The tenant has to pay you that civil debt, that 75%, on October 1st, and if they don't, then you can go back to that pesky small claims court on November 1 or file a regular civil lawsuit on November 1. Okay, but what about the 25% of the rent that's due from September through 1, that's when the transition time period goes, through the end of September? Remember, they owe, that's 13 months. Potentially they owe you 25% of the 13 months, and that's rent. So can we immediately go forward with that eviction? Because, hey, I served a 15-day notice. They did return the declaration. We do know that they owe 25%, and we do know, even under the latest extension, that they got to pay it by September 30th. So if they don't pay it by September 30th, we can immediately go forth and file an eviction law firm. I see that number right behind that guy's right shoulder, and I'm going to call him and we're going to go forward with that lawsuit because that is rent and it's due on that date, correct? And the answer is no. We have to do something else. So this is what occurred on June 25th. Number one, there's special language that has to go into your notice. And if that language is not there, your notice is no good. So basically, it's got to be in 12-point type and it's got to be bold and all this crazy language that has to go into the notice to pay rent or quit. But before you can file the lawsuit, I kid you not, you have to apply to the state for rent relief. You have to apply to the state. They're going to allegedly pay you 100%, yeah, right, if you qualify and if the tenant also accepts the invitation and applies as well. So before you can file any eviction lawsuit, you're going to first have to apply to the state of California. It's going to be under this website called housingiskey.com. Housing is ISKEY.com. You're going to have to apply for that. And then if you apply for that, and if the tenant applies for that, then technically you're going to get 100% of your rent. I'll believe it when I see it. Right now, the current program is not being administered at all. Very few people, everybody's applied for it. Either the tenants haven't applied for it when given their invitation, or they don't qualify for it because it's really only low income people that do qualify for it. So they're making you actually apply. This has come October 1, apply for that program. And then the tenant's going to have a certain amount of time to accept the invitation and also apply. The tenant's going to have, you have to wait at least 20 days. If you haven't gotten a rejection or a confirmation from the state of California, then you can bring forth the eviction based on the 25% of the rent that's owed. Again, you're going to have to wait till October 1st to see if they pay you the 25%, and then you'll be able to apply under Housing is Key, and that will give them 20 days for the state to say, hey, your tenant didn't apply, or we reject, or we accept. Within that 20 days, then you'll finally be able to bring forth an eviction based on the 25% of the rent that was owed for the transition time period. Don't forget that for the protected time period from March through August 2020, and the 75% of the rent that's also considered now a civil debt from September 2020 through now September 30th, 2021, that's all a civil debt that has to be handled in small claims court unless the government picks it up and pays you the 100%. I have my doubts. The current program requires that your tenant be earning 80% of the median income for the county upon which they live. So very few tenants could actually apply for that because they didn't qualify. And therefore, many landlords who applied, either the tenants wouldn't accept the invitation, this is for the 80%, 20% program, or they just chose not to do it because, tenant's going to say, what do I care? I don't think the landlord's going to chase me. They move away and they just don't care. Technically, the tenants will be absolved of 100% of the debt if the landlord applies for this. But again, we're not sure what the program will be, but it will be administered as of October 1. So don't forget, you can't just immediately start an eviction case based on the 25% of the rent owed for the transition period. You're going to have to first apply to the state. Maybe you'll get your money. I don't know, but I have very few clients who have gotten the money under the current program, very few. And then on October 1, apply, and then potentially we'll finally be able to get a little justice here by evicting some of these tenants. that's basically concludes, before I put everybody to sleep here, the differences between the Tenant Relief Act, the also statewide rent control, that it is now extended through September 30th. We know now that this program will end with certainty as of September 30th, which means your tenants will owe you standard rent for the month of October, serve your 3-day notice. We also know that for renovation evictions, those can go for statewide rent control as of October 1st. And as of October 1st, for your realtors out there who just want the tenant to move because we want to sell the property, we can go forward with just straight notices to quit. I'm going to open it up to questions now. Take it easy on the old man, but happy to assist for a little bit and answer as many questions as I can.
Hi, thank you so much, Dennis. I think the first question we had was regard to, does it apply to the city of Arcadia? Is there any difference? And then the follow-up to that would have been, what about PUDs? Do they fall into the same category as single-family residents?
Well, with regard to Arcadia, Arcadia doesn't have rent control. So I don't believe that's part of the city of Los Angeles, Arcadia. So you fall under statewide rent control. And the same things would apply. If you're talking about multiple units, as opposed to a single family home or a townhouse. So you would be able to raise the rent right now to 8.6%. You do need to have good cause to evict. We can evict right now on the basis that we want to move in a family member. If your property is actually in escrow and the owner intends to move in, that would be a proper reason that we could do right now.
Okay, that's awesome. You just actually knocked out the next question as well. Let's see. I think this one's already been repeated. Can the landlord apply for landlord relief? And is that in October that they can apply for this?
Well, under the current program, which you can apply right now, you have to give up 20% to get 80%. So the new program is going to start, as my understanding, and again, this is so brand new that I'm making intelligence decisions by reading this, but the programs really haven't been set up fully with all of its requirements. What I talked about, which was getting 100% of your rent, you're not allowed to file an eviction case until you show the rejection to the court that you applied. And this is under the 100% rent increase. I don't know where the state's getting all this money from, by the way, but I guess it really doesn't matter because the country is going to be in high inflation shortly, which is why my daughter can't find a house, for God's sakes. But yeah, you can apply now for I'd apply now, apply it all. But again, I'm reading in the notes here that someone said that they applied for it and they haven't heard anything back on that.
Yeah. For Arcadia, for single family residents, can they raise 10% or more with a 90-day notice?
If you're going to raise it more than 10%, and you certainly can, you need to serve a 90-day notice. If you're serving it 10% or less, then it's a 30-day notice. And if your property is not at market value, then you need to immediately raise that rent to market value. People are caught when you're all of a sudden your property wasn't under rent control and now magically it is. But if you were diligent and always had rents at market value, then you're way ahead of the game. When someone tells you that landlords are involved in rent gouging, that is just a total garbage line. There is no such thing. It could never happen. That would be like you guys taking a listing on a house that's worth $1 million and the owner wants you to list it for $2 million. And if he said, well, I want 2 million, your choices would be really simple. After you finish laughing, you could tell him that I'm not going to take the listing because it's a waste of time. Or you could take the listing, list it for $2 million, and then in 30 days, when you haven't gotten one damn phone call, you go back to the owner and you say, well, maybe we should lower it because remember I told you this place comps out at 1 million. Nothing sells or releases for more than it's worth. Nothing. That's what our free market is all about. And therefore, if anybody ever uses the term, well, we need rent control, because those landlords, they're rent gouging. There is no such thing as rent gouging, okay? That's some poor theory on the left, which is trying to affect income property owners.
Thank you. What about 2 units? I think you mentioned it earlier. There are 2 units. How does it apply if it's together and then separate in the city of Temple City?
Okay, so for Temple City, if you have 2 or more units, you're under statewide rent control, unless the property was built within the last 15 years, or if the owner lived in one side of the duplex and lived there prior to the tenancy being initiated with the other tenant. So you wouldn't be under rent control then. Otherwise, you're subject to, your normal rent increases, currently 8.6%.
Now, for PUDs, which category do they fall under? Do they consider condo, single family? Is there any special rules for them?
With regard to PUDs, are you referring to separate units that are built in the back? What are you referring to?
That's a really good question.
I mean, we call it accessory dwelling units. Is that what you're referring to?
Oh, no, I think they're calling it, the answer is yes. And I believe they're talking about single family PUDs. They're recorded as PUDs instead of SFR.
Okay, then what would be the difference? Help me.
Usually they probably have an HOA, right? They're
Okay.
usually gated communities, but they're separate units.
Right. If it's what they call alienable, if you can sell that unit by itself, then that constitutes a condo and it's not subject to any rent control.
Now, here's a question that I've had. Now, if a couple's income exceeds a certain amount, do they qualify for the COVID rent relief, whether
Well,
as a renter or as an owner?
Well, the owner's financial conditions are irrelevant. The tenant, the way the law is currently written, is that if the tenant has to make less than 80% of the median income for the county in which he lives. So most people just aren't in that category, so they don't qualify. This is under the 80-20 rule. As to what the new program will be come October 1st, where they're offering now 100% of the rent, God only knows at that point. But if they make it 80, if they make it where you have to be at less than 80%, then the politicians are going to get their wish. And their wish is that there will be a tidal wave of evictions, because the tenants will either not be able to apply for this 100% rent reimbursement, or they just choose not to. So then what's going to happen is we'll be going forward based on the fact that the 25% of the rent wasn't paid during this transition period.
Okay. Next question is very common. Now, if the owner wants to sell the property, the tenant's not really cooperating, and leases are expired, they're month to month right now, what should be the next step?
Okay, are we talking about a property not subject to rent control, like a single family home? Because in that situation, we would just want to serve the tenant with a 60-day notice to vacate on the basis that you're not subject to rent control. The proviso with the law now is that you can't get a judgment prior to October 1. So if we serve it now, we wouldn't get a judgment prior to October 1, so we'd be fine.
Thank you. Would a tenant in common under the state or citywide rent control, does that consider single family for rent control?
Again, if your property is alienable, okay, which means that it can be sold separately, Like if I own an 8-unit apartment house, I can't sell 2 of the units, right? Because you're under one roof and it's under one deed. But if you've got separate deeds and separate tax bills, those are not subject to rent control. They come under the condo townhouse definition.
Thank you, Dennis. Is there any other questions?
If there isn't, then I want to thank you very much for the opportunity to address your group. I always have a good time with this. And we do have a toll-free number, 1-800-77-EVICT. If you guys got any further questions, I've got a staff of, I think we're up to 20 attorneys now. And ladies and gentlemen, I am so old that 2 of those 20 attorneys are my children. So, and I wish they would get to the office on time, but we'll discuss that at a later point.
Okay, Pauline, back to you.
Wow, thank you. Thank you. And we all learn an update for this critical and the most important topic in our real estate, right? Dennis, you're helping us and we thank you so much. Everyone can contact Dennis' office after the meeting, or you want to review the video. Video will be coming in 24 to 48 hours to send to our members, or you can click the YouTube with WSGVAR's TV, and you're welcome to check with him most update information and get help for his expertise action, right, Dennis? So we want to thank you so much again on behalf of West and Gabriel Valley Realtors. We would like to thank attorney Dennis Block, give us so wonderful and informative presentation. With your expertise, your experience, your knowledge, you definitely can help us to get through this critical moment and help tenant, no matter tenant or landlord or our real estate agent, to have a happy ending. Hopefully that can be come out by the October. And thank you a lot. I want to make a short reminder. Tomorrow, we also have a very good class we call Hurdler System. It's about 11 to 12. Check with WSGVAR.com education class schedule. And this one can help you automatically track your business expenses, mileage, income stream, and tax deduction items. And don't forget, tune in Thursday. Our Emirates Breakfast meeting will bring you a wonderful celebration, 4th of July, our nation's celebration, right? And after that, for July 13th, Tuesday, 12 o'clock, commercial seminar, capital gains. This is very important, calculation, how to earn the money through your investment. And tune in, that's one, very simple. Jeff, how to register? Do you know that? WSGVAR.com, and then click the education schedule, right? We see you Thursday morning at 9 a.m.